The court further upheld the power of the executive to transfer High Court judges without their consent, provided the constitutional procedure of consultation was followed. It rejected the contention that judicial independence required the CJI's opinion to be final and decisive in appointments. As a result, the petitions challenging the non-appointment and transfer of judges were dismissed. Although the judgment affirmed executive primacy, it was widely criticized for weakening judicial independence. This criticism later led to a change in approach, and the decision was overruled by the Second Judges Case, 1993, which established the collegium system. Reasoning of the court. The court reasoned that the Constitution did not expressly give absolute authority to the judiciary in appointments. Giving complete control to judges was seen as inconsistent with democratic principles and the constitutional scheme. Impact of the judgment. This decision gave greater control to the executive over judicial appointments. However, it was widely criticized for weakening judicial independence and allowing possible political interference in the judiciary. Another important issue was whether the First Judges Case, 1981, which gave primacy to the executive, was correctly decided or required reconsideration in order to protect the independence of the judiciary, which is a basic feature of the Constitution. The court also examined whether the opinion of the Chief Justice of India should be individual or collective, and whether judicial appointments should be based on the sole opinion of the CJI or a group of senior judges. Thus, the case raised fundamental constitutional questions relating to judicial independence, separation of powers, and the balance between the executive and the judiciary in the process of judicial appointments. Judgment decision. The Supreme Court of India overruled the First Judges Case, 1981, and held that judicial independence is a basic feature of the Constitution, which must be protected in the process of judicial appointments. The court ruled that the word consultation in Articles 124 and 217 does not mean mere advice, it means effective consultation amounting to concurrence, thereby giving primacy to the judiciary over the executive. The court further decided that the opinion of the Chief Justice of India, CJI, would have primacy in appointments, but this opinion must be formed collectively, not individually. Accordingly, the CJI was required to consult senior judges of the Supreme Court before making recommendations. This collective decision-making was intended to prevent arbitrariness and ensure objectivity. By this judgment, the court formally introduced the collegium system, under which judicial appointments are made on the recommendation of a judicial body rather than at the discretion of the executive. The President, and the government, must ordinarily act in accordance with these recommendations. In effect, the decision shifted control of judicial appointments from the executive to the judiciary, strengthening judicial independence and reducing political influence. This judgment became the cornerstone of the present appointment system, later clarified and expanded by the Third Judges Case, 1998. Creation of the collegium system. The collegium system was created by judicial interpretation, not by the Constitution or Parliament. It was formally established by the Supreme Court of India in the Second Judges Case, 1993, I. Supreme Court Advocates on Record Association v. Union of India. In this case, the Supreme Court overruled the First Judges Case, 1981, and held that judicial independence is a basic feature of the Constitution. The court interpreted the word consultation in Articles 124 and 217 to mean effective consultation amounting to concurrence, thereby giving primacy to the judiciary in the appointment of judges. It held that the opinion of the Chief Justice of India, CJI, would have primacy, but such opinion must be formed collectively with senior judges to avoid arbitrariness. Thus, the court created a system where judicial appointments are made by a collegium of judges, rather than by the executive alone. This system was later clarified and expanded in the Third Judges Case, 1998, which fixed the collegium for Supreme Court appointments as the CJI and 4 senior-most judges. The collegium system was created to protect judicial independence by limiting executive control over appointments, and it continues to govern the process of judicial appointments in India today. Significance. The creation of the collegium system is highly significant in Indian constitutional law because it strengthened the independence of the judiciary, which is a basic feature of the constitution. By giving primacy to the judiciary in the appointment of judges, the Supreme Court of India ensured that judicial appointments are free from political or executive interference, thereby protecting the impartiality of courts. The system shifted control over judicial appointments from the executive to the judiciary, reducing the risk of appointments based on political considerations. It also introduced the idea of collective decision-making by senior judges, which helped prevent arbitrariness and ensured that appointments are based on merit, integrity, and competence. Further, the collegium system played a crucial role in maintaining public confidence in the judiciary. An independent judiciary is essential for protecting fundamental rights, upholding the rule of law, and acting as a check on the other organs of government. Thus, the significance of the collegium system lies in its role as a constitutional safeguard that preserves judicial independence, fairness, and democratic balance, making it a cornerstone of India's constitutional framework. Conclusion. The second judge's case is a milestone in Indian constitutional law. By giving primacy to the judiciary and introducing the collegium system, the Supreme Court ensured that judicial appointments remain independent, impartial, and free from political influence, thereby safeguarding the rule of law and constitutional democracy.